Okay.
What is an uncontested divorce?
An uncontested divorce is when two people have decided they want a divorce and they've really settled all issues. They're not fighting about anything. So it's also considered a simple divorce.
How much will my divorce cost?
It really depends. It could cost as little as the filing fee, which in South Carolina is $150. That would require you doing the divorce yourself. And if you felt comfortable, you could certainly do that. The family court, it's my understanding, they offer a packet which you could go get and file the divorce on your own. You could also find the files or the documents online. sccourts.org, that has our documents. So if it's a simple uncontested divorce, you could certainly try to do that on your own. However, most divorces are not uncontested or simple, and that's where you certainly need an attorney. Most family law attorneys, at least in this area, bill hourly and require a retainer up front. So that retainer, depending on all the issues in your case, could be higher or lower. I would say meet with an attorney, discuss how much that would be. Most attorneys are, their retainers are about the same as others. Some attorneys like us, we refund back whatever isn't used in that initial retainer or more money that it could cost later. The biggest issue is what problems are there involved, what assets, is there custody, is one person going to be harder to deal with, are they going to respond the way they should? It's really so many things that can determine how much it will cost. But again, most attorneys bill hourly, so that's how you will be charged.
What do I have to do to get the divorce process started?
You come see us. In all seriousness, you file a summons and complaint just like any other lawsuit. You can do that on your own, or you can have your attorney do it for you. If you feel you're going to need an attorney, it's best to have the attorney to do that in the beginning, because there may be issues or facts that you would not list yourself that an attorney would need to list anyway. After that is filed with the court, you're going to have to properly serve the other party. And a lot of people get confused with that. So again, if you're going to need an attorney, it's best to go forward with an attorney in the beginning.
What is a no-fault divorce?
A no-fault divorce is a divorce based on the parties living separate and apart for more than 1 year. It requires you to live in separate homes. You can't stay in the garage, or you can't stay in another bedroom in the house. You have to live at a different residence for more than 1 year, and without cohabitation. And that also means if the two of you decide to get together, have sexual intercourse, that could restart the clock. But there are 4 fault grounds in the state of South Carolina, unless someone's at fault for adultery, physical cruelty, habitual drunkenness or drug use, or abandonment for more than 1 year is still recognized in South Carolina. However, we never really see anyone get a divorce based on abandonment, because you still have to live separate and apart for a year. So typically we will just go the uncontested, or the no-fault divorce route of the living separate and apart.
What is the difference between legal separation and divorce?
Well, in the state of South Carolina, we do not have what's called legal separation. We have a person can file for separate support and maintenance if they need or feel the need to do so, or if they have reasons to do so. A lot of times, if there is no fault, the parties can just live separate and apart for a year if they're getting along.
Good. Oh, sorry. I didn't mean to ruin for. Sorry about that. It was
okay. I thought it was dead.
No.
Okay.
Sorry about that.
Let's do it again.
Okay. Go ahead. Let me situate something real quick.
Okay.
You moved once and the chair hit the thing.
Okay.
And it spun just a little bit, so I was just going to zoom. But you're good. Let's go.
Okay.
What's the difference between legal separation and divorce?
Well, in South Carolina, there's not what's considered a legal separation. In South Carolina, you get divorced, or either you can file for an order of separate support and maintenance. And that's not always required or necessary. A person would file for separate support and maintenance if before they can actually get divorced, there needs to be a decision based on the assets, child custody, if there's restraining orders that need to be put in place, those sort of things. But if people are getting along fine and there's no issues, then they can certainly wait for the 1 year just to get the divorce. But again, most of the times that's not the case, and there are some issues between the parties. So to protect yourself, if you don't have a fault ground for a divorce, oftentimes it's best to go forward for an order of separate support and maintenance.
How long does it take to get a divorce?
Well, by statute, if there's a fault ground, you can get a divorce in as little as 90 days, or you can get a divorce based on 1 year. Now, I typically tell clients or potential clients, it's usually never 90 days or 1 year exactly. I mean, we have to factor in time for filing with the court, scheduling. Is there going to be mediation, scheduling things with the other side, with the court schedule? But it's a minimum of 90 days, and if it's for a no-fault divorce based on 1 year separation, it's at least 1 year.
Will I have to go to court?
The majority of the times, yes, you will need to go to court. There's situations where you wouldn't. Say if you were a defendant in an uncontested divorce, you could just sign an affidavit, or you simply would not have to appear if you agreed with everything that the other side was requesting. But typically you would always go to court. There's usually a temporary hearing to decide matters on a temporary basis, and there's a final hearing or either a final trial depending on whether or not the issues have been settled. Now, there are other situations like we're dealing with now. If you've got something like COVID, scratch that. God. Okay.
Sorry.
Can I go to the next one?
Yeah, go to the next one. I guess if you can just do that. So.
Yeah, we're good.
What if I can't locate my spouse?
If you cannot locate your spouse, the divorce can still be filed, and it would be filed in the location where the two of you last lived. Scratch that. Let's do that again.
Okay.
Okay. Say it again.
What if I can't locate my spouse?
Well, that's normally okay. It's better to have all parties involved, especially if there are contested issues. If you can't locate your spouse, we have ways to try to locate them. But worst case scenario, we will have to get an order from the judge for service by publication. We will have to show the court that we've exhausted all other ways of trying to serve your spouse, and once we've done that, the court could grant that order of publication, where we then serve that person by publishing it in a newspaper and letting it run for consecutive weeks, proving to the court that's happened. And we would run it in the newspaper where they were last known to reside. And we can then move forward with the case as long as we've proven those things.
Will I have to pay alimony?
Whether or not you have to pay alimony depends on several factors that the court will look at. Were you at fault for the divorce? What is the earning potential of either side? Who earned the majority of the income? What standard of living everyone is used to? The age of the parties? There are many factors that go into that, but there's also some factors that could keep you from having to pay alimony. But again, that's something that it would be best to have a consultation with an attorney to look at your case, because all cases are different and facts are different. So experienced family law attorney could go over that with you and explain to you better.
Okay. Do you want to say anything else about divorce and going to custody?
No.
Okay. If one parent moves out and leaves the kids with another parent, does it hurt the moving parent's chances of getting custody at a later date?
Well, the court will look at the factors as to why the parent moved out to start with. Generally, a good attorney who's representing the other side will try to point out, well, they left the children with this parent, so they must not want custody of the children. But again, there's different factors for each case. There's ways to look at it, to present the facts and why. But generally speaking, the parent that is providing I've got to do that again. Son
You're right.
of a- All right. I'm just going to go into it because you don't have to read it again. Generally speaking, the moving parent, I'm going to do it again. That really depends on the factors as to why the moving parent moved to begin with. The court will look at all of these reasons. An experienced attorney can help point out reasons and can help present your case as to why you may have needed to do that. Generally, the parent that stayed with the children, that has cared for the children the majority of the time, the court's going to wonder why. I can't do it. I can't do that one.
We don't have to do it.
I like the question. Here, I'll do a short condensed.
Okay.
All right. That really depends. The court's going to look at what were the factors and the reasoning for the moving parent to leave the children with the other parent. Every case is different, but it's best to meet with an attorney to be able to determine what was the reasoning, what's the best way to move forward, and how to present your case. But it really depends, but the court will look at all factors.
Are courts more likely to award custody to mothers than fathers?
No, they are not. In 1994, South Carolina abolished I just turned that way. Let me look at my paper real quick. Okay.